Hi, I'm Ed Alexander, attorney and founder with Alexander Abramson, a business law firm in Florida. And welcome to our Friday Mailbag. Today we're going to talk about two questions. One has to do with trademark, and then the other has to do with leasing. So Jennifer, who owns a food service business, has a question about a lease. It seems that her lease was up. Her landlord provided her with a replacement lease and expected her to sign pretty much an hour or two after she received the lease. And so, the question always comes up about leases. Lease has an enormous effect on the value of your business and on your ability to operate the business profitably. If you enter a lease that has some draconian provisions, you might not be able to sell your business. You might not be able to operate your business properly because the landlord would have too much control over your business, or frankly, be draining off too much of the resources. What you want to do is take a look at the business that you're in and kind of figure out what the ratios are. By way of example, is the lease rate that you pay for your business, should it be 5% of revenue? Should it be 10% of revenues or less? And make sure that you're not paying too much. But when it comes to the actual lease terms, expecting someone to receive a lease and then turn it around a few hours later is completely absurd. You should absolutely review the lease. Now, it's a little bit difficult for a business owner to just review a lease because you're reviewing one every maybe 5 or 10 years or something like that. And so you don't have that expertise. So it's worthwhile to have an attorney take a look at it for you. Because oftentimes there are provisions in leases that are what I call gotcha provisions. A notorious one would be in the event that you went to make an assignment to the lease, so when you were going to transfer or sell your business, you make an assignment of the lease, the rent ratchets to a different rate. Or, for example, I've seen ones that deem an assignment of the lease when there's only a small change in the ownership of the business. Let's say you bring on an investor or you add a key employee into the ownership. So these are things you want to really read through the lease and make sure that they're not in there. There's a lot of various gotcha provisions, and obviously 2 hours is not enough time to get advice and to review. It also highlights another issue, and that is anytime somebody provides you with a really important document or expects you to do a really important deal, and they won't give you time to really mull it over, think about it, get some advice about it, that's a major red flag. Maybe they're just not experienced. That's a possibility of this, and I think that was the case here. They're just not experienced in it. But on the other hand, it really brings into question the overall expectations regarding the relationship. So if somebody's giving you a document, whether that's a lease or a major contract, and they're expecting you to sign it and turn it around without reading it, pause and think about what it is that's really going on here. Okay, the second question has to do with trademarks. And we had a question about getting a trademark on a company name. Now, trademarks are traditionally used to identify the origin of goods. And so a trademark is either attached to the product itself or it is attached to the packaging for the product. And so a name of a company in the abstract, not being used with a service, not being used with a product, cannot be trademarked because it's not being used in that manner. So what you want to be looking at is, are you using a company name for a service, on your product, doing something like that? Then it can be the subject of a trademark application. But if you're just using it as a company name, then as a general rule, it would not be capable of being protected in that manner. So what's the planning option here? The planning option is, if you know that you want to trademark the company name, then use that name. Most easily, it can be used in connection with the service. But if you can't use it in connection with the service, then perhaps it becomes the name of a particular product that you're offering or something like that. And remember, when you get the trademark, it is for a particular category or categories for which the mark is being used or will be used. It's a little bit of a complicated area, so if you have any questions about that, be sure to let us know. Well, that's our Friday mailbag. Thank you for watching. Again, if you have any questions, if things are going on that you want a little bit of help on as this lockdown coronavirus situation continues, please be sure to give us a call. We're doing 15-minute calls. We'd love to be able to help you out, get you pointed in the right direction. We want to be a resource for you. All right, well, thanks for watching. We'll see you next week.